But before that, let's just throw some light on AstraZeneca. Sebi has actually ordered a close scrutiny of the AstraZeneca India delisting, and we understand that there is some evidence of concerted action between the company and the FII. So let's get J.N. Gupta, the former executive director of Sebi, who joins us on the phone line from Mumbai, to tell us what are the red flags that Sebi has raised and what could be the way forward from here. Mr. Gupta, thank you. I understand that you're going to board a flight, so thank you for sparing some time for us. Can you just throw some light on what exactly is the concern that Sebi has raised and what could be the way forward?
See, the exact concern of the Sebi is this, that the delisting process which is presently in vogue is supposed to be a process where the price discovery takes place in a fair manner, in a reverse book building method. And now, in this case, what is happening, the companies have been using a camouflage method where they have earlier placed shares by way of OFS to related parties, and then those related parties participate in the reverse book building. So the entire process of price discovery mechanism to the reverse book building is vitiated. And this is the concern where, because it is unfair trade practice in the sense that the company and those investors who have taken shares in the OFS have been hand in gloves together and participated in the tendering of the and in the delisting process. And if you recall, in AstraZeneca case, there was a case where when they had announced this OFS, just before that they had said that the company, the parent company, is going to put in something about 100 crores or some odd amount as a non-refundable grant. Now, I had raised the question at that time itself, when the moment a parent is putting non-refundable grant in a listed company where it is not owning 100%, there has to be something there. And immediately after, there was a OFS, and as we are seeing now, that OFS resulted in a share being parked with the related parties, and those related parties ultimately tendering the shares in this. So it is an issue where the entire regulatory process has been mocked and people have been taking it by. And I have always been of the opinion that either the delisting process has to be simplified, which I think the Sebi is putting an effort by having a consultative paper on delisting. But the fact is that the regulations have to be tightened and enforced. Because if we do not punish people who are violating the law, then there is no question or there is no purpose law serves, and there should not be any law. So we have to enforce it, and It is a very good thing that Sebi has done, that they have caught the wrongdoing.
All right, Mr. Gupta, my colleague Nimesh is also here with us. He would like to ask you a few questions. Nimesh?
Mr. Gupta, thank you very much for joining us this morning. Sir, the Sebi order very clearly says that the next move, or possibly what they have done, is they've asked BSE and NSE to closely examine the entire delisting process. What do you mean by that? What is that the NSE and BSE should look at so that there is a transparent and a fair delisting in AstraZeneca?
See, the issue is very clear that BSE and NSE would have to observe how the delisting process or reverse book building was done. But ultimately, it is going to be discovered that all those 6 OFS investors were the people who mattered for the delisting. So ultimately, because there is nothing going to be a very different observed by BSE and NSE, what has already been observed by Sebi.
So, Mr. Gupta, is there a way out that, in this delisting process, Sebi and NSE will, make sure that the 6 entities who are holding 15.5%, they have been, looked upon separately, and the minority shareholders, the bid price at which they put in their bids, that will be looked at separately, and then take a call on, because, the onus is now on Sebi, on BSE and NSE to finally approve the delisting process. Sebi has very clearly said that NSE and BSE will take a final call on whether they should approve this whole delisting process. So, in that case, should the BSE and NSE look the 2 entities differently, the FIs which are holding 15% and the minority shareholders, the bid price of both, and then accordingly take a call on the delisting process?
In my opinion, this has to be a bigger issue, because if it is found that OFS process was vitiated and it was a managed process, that means you are hitting the OFS itself. The delisting comes post OFS. So in my opinion, if Sebi has found that OFS process was initiated, then the first penalty has to be on the company for non-compliance of minimum public shareholding norm or compliance in a wrongful manner. That is the first. Now, assuming Sebi did not hit the OFS process and it looks only to this, then I do not think within the law they will be able to differentiate between other shareholders and FII, because if the matter goes to the court will always say that we have to follow the law. So unless until Sebi hits the OFS process itself and say that it was wrong, it will be difficult to say that delisting process should be applied separately for minority shareholder other than the institutional shareholder.
Okay.
That will not be possible.
Okay, so Mr. Gupta, essentially this case should not be too different from Fresenius Kabi in that case, right? I mean, AstraZeneca will have a similar set of lawyers and they would defend their case, and it looks like it would only delay the process but not stop it, that as we found out in case of Fresenius Kabi, and really the root of the problem has to be attacked.
No, again, as I am insisting now, that in Fresenius Kabi the mistake that was that the Sebi hit only the delisting process, or that you cannot delist. I was of the opinion that Sebi should have said that your OFS was wrong, reverse the OFS. And if they continue with this logic here, they will be successful. Because the root cause of problem is that they have gone through the OFS in a vitiated manner. Or the whole process is vitiated.
All right, Mr. Gupta, thank you for your thoughts. We'll leave it at that. That's the word coming in from the former executive director of Sebi on how the entire process of the regulatory process is being marked. But